In this session, we're going to cover the first topic of torts. That topic is intentional torts. Before we begin discussing intentional torts, I'd just like to say that, like some of the other material we've covered, torts is a class that you cover your first year of law school. Torts would be your first semester and your second semester. So in this chapter, about 40 pages, the textbook has condensed down an entire year worth of law school for us to examine. So you may have heard someone use the term tort. What does it refer to? What does that mean? A tort is simply refers to a wrongful act in which an injury or a harm is caused to a person or to the person's property. In a tort case, the person is seeking compensation for the injury to either themselves or their property. So harm happens to the person. If someone is injured, they would be seeking monetary damages to make themselves whole as a result of the injuries they sustained because of the wrongful act. So you think of a tort and maybe you hear personal injury and civil wrong, and so you wonder what's the difference between a tort and criminal law. Well, the major distinction is that with a tort, it's not an act that is outlawed by society. Criminal law is a set of conduct that society has decided is improper and cannot be permitted in a civilized society. So, stealing, robbery, fighting someone with serious injuries, killing someone, various conduct that's not permitted. But in tort, you're talking about some conduct that's happened that's caused injury, but it's not conduct that has been criminalized by society. So there are three types of torts that we'll talk about. First is intentional torts, and that's the tort that we're going to cover in this session. Then in a later session, we're going to talk about negligence and gross negligence. And negligence is really what makes up the bulk of tort. As far as the lawsuits that got filed, the tort lawsuits that get filed, they are primarily a negligence-based lawsuit. The intentional torts that we talk about are torts that are out there and happen, but negligence is probably 85 to 90% of the tort cases that happen, in whether it's business or just in context between two individuals. Negligence is by far the largest category of tort lawsuits. So let's briefly distinguish intentional torts from negligence. And we'll talk about negligence in much more depth in another session. But it's important just to briefly understand the difference between an intentional tort and negligent conduct. So the main distinction between these two types of what conduct you deem to be an intentional tort and what conduct you deem to be negligence. The determining factor in distinguishing between the two is the intent of the wrongdoer. So intentional torts have an element of intent or purpose to commit the act. That means the defendant was acting deliberately. In an intentional tort setting, there is an intentional act. The act that's being done is deliberate. By contrast, in a negligence action, you lack that specific intent, that deliberate action. Usually is the result of a failure to follow or use proper care. So in the common classic sense, negligence oftentimes is an accident. If you think about a car wreck, are car wrecks intentional? Often no. Most car wrecks result because of an accident. There may be some negligent conduct, such as following too closely or speeding or not looking properly, and that's the result of a failure to use proper care. So if you're driving down the road and you're not paying good attention and you don't realize that the stoplight has turned red and you continue moving forward and you strike another car, that is not an intentional tort. Rather, that is negligence because it was your failure to use proper care to observe that the stoplight was turning red. By contrast, an intentional tort is one in which you mean to perform that act. So if it was someone coming through the intersection that you had a grudge with and you hated and you wanted to wreck their car and you purposely went through the light because you wanted to hit them and then you hit them, that would be an instance of an intentional tort. So let's look a little closer at intentional torts. For an intentional tort to exist, the plaintiff has to prove these four requirements. You have to have intent. Intent, as we'll talk about in just a second, can either be implied or you can have actual intent. The plaintiff also has to prove that it was a voluntary act by the defendant. You also have to show causation. And lastly, you have to show an injury. So the causation element is what connects the implied or actual intent with the voluntary act with the injury. So the intent to carry out this voluntary act has to be the reason that the injury occurred. Without that connection, that causal link, then you don't have a recoverable intentional tort. So if someone, let's take an example of Andy does not like Samantha. So Andy intends to throw a baseball at Samantha. He throws the baseball at Samantha and hits Samantha, and Samantha falls down. Well, as Samantha is getting up, Samantha then trips and falls back down and lands on her arm and breaks her arm. Well, there was an actual intent there to harm Samantha because he intended to throw the ball at her. That was a voluntary act. He decided to do it, and then there's an injury, the broken arm. But is there a causal link between the voluntary act of throwing the ball at Samantha and the injury? The answer is no, because that act didn't cause the injury. The injury was caused because Samantha stumbled and fell. So in that scenario, you would not have an intentional tort. By contrast, if the ball had knocked her over, and when she fell over and landed, if she had broken her arm at that point, it would have been an intentional tort because the cause for the broken arm was her falling over from being struck by the ball. So let's talk a little bit about intent. Intent is where you're acting with a purpose, or you have knowledge that the act can cause an injury or harm to another person. So this is looking at what did you mean or intend to do? What was your intent for what you did? So the defendant, the person doing the harm, does not have to know that the injuries would occur. Rather, the defendant only has to know that the act may have consequences. So in our scenario of them throwing, forget the guy's name, maybe I said Andy, but the boy throwing the ball at the girl, Samantha, he did not have to know that the ball would knock her over and cause her to break her arm. Rather, all he has to know is that throwing the ball and hitting her may have consequences. And so in that scenario, knowing that he could throw the ball and hit her and possibly have consequences, that's enough to establish an intent. So a moment ago, we talked about intent can either be actual or implied. So actual intent is where the defendant intended for the specific consequence to occur to the plaintiff. And we're going to look at a few examples of actual intent and implied intent on the next slide. Implied intent is where the defendant knew that the consequences of the act were certain or substantially certain to occur, although the defendant may not have intended any consequences. And the Last point to make is that intent can be transferred. That means that the intent may be meant to carry out the act, but it was directed at one person. But if you actually cause harm to another, that intent is transferred to where you can't say, well, I didn't intend to hit Samantha. I intended to hit somebody else that's there or some object. If you, it's not a defense to say, well, I wasn't trying to hit them, I was trying to hit somebody else. That's not going to be a defense. Rather, the intent is going to be transferred to the unintended person. So let's look at some examples here. So actual intent. John is mad at Adam for eating his ice cream sandwich. Who wouldn't be mad? So John decides that he's going to punch Adam in the face. And John does that. John had the actual intent here to harm Adam, and he had the actual intent of punching Adam in the face, and he did it. So that's an example of actual intent. Implied intent, just the classic example is given in the textbook, and that's where Winston is working at, or Wilton is actually who it is working in his office building, and he goes to the window and throws some trash out. And it falls from the window and it hits Olivia, who's walking by on the sidewalk, and it causes an injury. Well, there, Winston didn't have a specific actual intent to throw the trash and harm Olivia, but he was certain or should have substantially known that throwing something out of a window could hit someone and cause harm. And so that would be the classic example of implied intent. Transferred intent. Let's go back to the example with John and Adam. John's still mad at Adam for eating his ice cream sandwich. As such, John throws the punch at Adam, but Adam ducks and John punches Tina, who is beside Adam. And so in that example, the intent, John had no intent of punching Tina. He intended to punch Adam. But that intent would be transferred from Adam to Tina, such that Tina would be able to establish intent for the purposes of an intentional tort against John. So on intentional torts, there is a defense when there's consent. So that makes sense. If someone consents to the act and then they have harm from the act, it doesn't seem fair for them to then be able to sue the person that inflicted the harm. Everybody was in agreement. So if the plaintiff agrees to the act that the defendant does, there's going to be no recovery for an intentional tort. The example here that I give is John and Ted agreed to wrestle one another on the trampoline. During the wrestling, Ted is injured. There's an agreement there for them to wrestle. Ted would not have an intentional tort against John because of his consent. It's important to note as well that consent can be implied. The classic example is sporting events. When you're playing football, it's implied that there's going to be contact and that someone may be injured. It happens all the time where somebody tears an ACL or hurts an arm or breaks a bone because they're being tackled in football. You don't see football players suing other football players because of an intentional tort of them being struck when they were running with the football. Instead, consent is implied in that scenario and would act as a defense to any possible intentional tort claim. So there are a number of intentional torts, and we're going to look at these briefly. But these include battery, assault, false imprisonment, intentional infliction of emotional distress, defamation, trespass, nuisance, conversion, and fraudulent misrepresentation, as well as a few others that we'll cover. Let's begin with battery. Battery is the non-consensual and intentional harmful or offensive touching of the plaintiff's body. So this is where there's an actual contact. So let's take our example that we talked about with the actual intent a moment ago, where John throws the punch at Adam. That is going to be one, intentional, two, it's not something that's consensual, and it's a harmful or offensive touching of the plaintiff's body. So in that scenario, John has committed the intentional tort of battery. So the contact that occurs may be by an extension of the defendant. So in that example, let's go back to the case where the boy threw the ball at Samantha. In that example, the contact occurred by the ball, which is considered to be an extension of the defendant because the defendant's the one who set it in motion and threw it at Samantha. So it's not a defense to say there wasn't a battery here because all I did is I threw a ball at Samantha. That would still qualify as a battery because it's an intentional and non-consensual harmful or offensive touching to Samantha's body. It's even possible for a battery to occur when there's no injury. The example that the book gives, which is a good one, is when you spit in someone's face. That's an intentional, usually most of the time. I guess you could accidentally let a little bit of spit out, but if you're in the scenario I'm thinking of, is you just straight up spit in somebody's face. In that example, it's not consensual. It's an intentional touching of the plaintiff, and it is obviously offensive to the person, although it may not cause injury. That would be enough to qualify as a battery. And like we talked about, the contact may occur by putting something in motion, and that's the example of throwing the ball or throwing a stick that hits the plaintiff. Next, assault is, you usually think of assault and battery together, but there is a big distinction between them. Assault, the distinguishing factor is that with an assault, there's no requirement of there being a touching. So for me, I hear assault and I always think of they've like physically assaulted the person. But in the context of an intentional tort, an assault does not require a touching. If there is a touching, then it would be appropriately characterized as a battery, not an assault. But oftentimes an assault accompanies a battery, and that's because assault is an intentional act that creates a reasonable apprehension of imminent harm. And so it's very often that you have an assault that then turns into a battery. So take the example of John and Adam. John's mad that Adam ate his ice cream sandwich. John may cock back his fist and create a reasonable apprehension in Adam of an imminent harm. He may have a reasonable fear of imminent harm because John has pulled back his hand like he's going to punch him. That is an assault. And then if he carries the punch forward and actually makes contact with Adam, then that turns into a battery. So in that example, you've got both an assault and a battery. So the assault is the attempt or the threat of harm, but there's no actual harm that occurs. When the actual harm does occur, then that's a battery. So the example that I give is that someone threatens to hit you with a bat, but they don't actually hit you. If somebody, if you say you're outside and somebody pulls a bat out and brings it up like they're about to swing it at you, that's going to create a reasonable apprehension or reasonable fear of imminent harm. And so that would be an assault. Now, it's important to note that assault requires the threat of causing the harm accompanied by the present ability to complete that act, to immediately complete that act. So you can't, if you threaten somebody but you don't have the means to carry out the threat, it's not going to be an assault because if you threaten somebody but you can't pull it off, then that's not going to be an assault. So the example I give is let's take the bat. If the person says, I'm going to hit you with a bat, but they don't have a bat, then there's no ability in the present, there's no facts in which the person should have a reasonable fear of imminent harm. If they're going to hit you with a bat, but there's no bat, then it's not a reasonable basis to fear imminent harm. Another example would be is if someone tells you next week, I'm going to do this to you, do an act. If they threaten to hurt you next week, that's not assault because it's not an imminent threat of harm. Now, the next week may come and they may be there to threaten you, and they may have the means with which to do it, and then you would have an assault the next week. But telling someone on Thursday that they're going to assault them the following Monday would not be enough to qualify as the intentional tort of assault. False imprisonment. False imprisonment is what you would expect based on the name. It's where you hold someone against their will without the legal authority to withhold them, to detain them. So someone comes to your home and they're there and they want to leave, and you tell them you can't leave, and you lock the doors and block them from leaving. That's going to be a claim for false imprisonment because it's a confinement that happens. You're restraining somebody against their will. It's a confinement that happens by either physical barriers, physical force, or threats of force. So you don't have to physically lock the door, but if you tell them if you leave and go out the door, I'm going to shoot you, or I'm going to hit you with a baseball bat as you're going to leave, then, and they're feel constrained and can't leave, in those scenarios, you're going to commit the intentional tort of false imprisonment. So it's important to note that the plaintiff actually has to know that he or she is confined. So if you're walking around at a department store, and say you go in Macy's, and Macy's locks the doors and won't let anyone leave. Well, if you're walking around shopping and then by the time you leave, they've opened the doors again, were you really falsely imprisoned? No, because you're not being held against your will. You had no idea that the doors were locked. So it's important or critical that the plaintiff actually know that they're being confined, because false imprisonment requires that the person be held against his or her will. And if you lack any knowledge of the confinement, how can you be held against your will? So for store owners, this often comes up for them, and I've defended a few cases where stores have been charged, or at least have been sued for false imprisonment because they have detained somebody who they believed was stealing or shoplifting. Well, in that instance, store owners are usually shielded from false imprisonment claims so long as they have acted in good faith, meaning that they had a good basis, uh, good facts to believe that the person being detained had actually shoplifted. And then when they do detain them, they've got to do it on a reasonable basis. So it's got to be reasonable in terms of the manner in which they approach them and detain them. It can't be, you can't be tackling them and handcuffing them and stuff. It needs to be in a reasonable manner of putting them in a room, only holding them for a short period of time until the police get there, things like that. But as long as the store owner acts in good faith and manner in which they detain the person suspected of shoplifting is reasonable, then the store owner is not going to be liable for false imprisonment. So the intentional tort of intentional infliction of emotional distress. This is a claim that you see alleged a whole lot in tort lawsuits, but it is a claim that really is a little hard to prove. And for that reason, oftentimes these claims don't make it too far. So they're often added to a lawsuit, but they're usually not successful in a lawsuit, at least in Tennessee, and that's my experience of what I observe. But this intentional infliction of emotional stress is where it's the act of causing mental anguish to another person through outrageous conduct. Tennessee recognizes this tort. They also recognize a negligent infliction of emotional distress, which, like we talked about a few minutes ago, the difference there is the intent. Here, it's a deliberate act, and a negligent infliction of emotional distress, you lack the intent. It's more of a failure to follow the proper standard of care. So to recover based on an intentional infliction of emotional distress, the plaintiff must show these four things. They must show that the defendant acted intentionally or recklessly. The defendant's conduct was outrageous. In Tennessee, outrageous is defined as conduct that a civilized society would not tolerate. Third, the plaintiff must suffer some severe emotional distress. And lastly, the defendant's acts must again be the cause of that emotional distress. So you've got to have that causal connection there. So the mental distress must be foreseeable from the defendant's actions. And most jurisdictions, including Tennessee, will require that a physical manifestation of the mental injury. So maybe where you're not sleeping well, you're not feeling good, you're having anxiety, maybe your blood pressure's up. Things like that would be a physical manifestation of the mental injury. So outrageous conduct, it's like I said, in Tennessee is defined as conduct that would not be tolerated by a civilized society. That's going to be more than just insulting, abusive, threatening, profanity, or annoying conduct. So it's really got to be something extreme and outrageous, as opposed to just being a jerk or being difficult to deal with, or being loud, using profanity. Things like that are not going to rise to the level of outrageous conduct. And like I was saying before, these cases are hard to prove, and this is one of the reasons, is that the outrageous conduct just doesn't mean the person's a jerk or they're difficult to get along with. They've really got to do something that is inappropriate. And the closest and the best example to use is like, sexual harassment in the workplace. Like that could be enough of an outrageous conduct that it would be something that society would be deemed to not tolerate, especially as the Me Too movement has been going on for the last few years. Society's viewpoints on what's acceptable and what's not is kind of tightening, and so it may make it easier to prove a intentional infliction of emotional distress claim in the context of a sexual harassment claim. So you've got the difficulty is proving the outrageous conduct, and the second difficulty is establishing that you do have a severe mental injury, emotional distress. It's got to be something more than I was upset over something and I, was worried about it for a few months and stuff. Usually, you've got some physical manifestations, and it often requires that you've seen a medical person. But medical evidence is not a requirement in Tennessee. You don't have to establish medical evidence in order to recover. Defamation. Defamation is the publication of an untrue statement, whether it is through oral or written publication. But it's an untrue statement that injures a third person's reputation. And defamation When we're talking about that, we're talking about factual statements, not opinions. Opinions about people um, are not, it's hard to prove that's true or untrue because it's an opinion. But a fact is something that is either true or not true. So the person either committed the conduct or they didn't. But an opinion about someone, and you'll take like public officials, the president, there's always opinions about him. Well, opinions about him, about how he's doing in the office, or how a policy is, or how a new law that he's pushing is opinion. What would be um, the possibility for defamation is when you're talking about factual statements that are untrue. So a factual statement claiming that the president embezzled money, um, that would be something that's a factual statement. That's not an opinion. And so that claim, if proved to be untrue and you meet the uh, intent requirement that we'll talk about in a minute for public officials, a little different than a private person, but that would be an example of a factual statement as opposed to opinion. The only exception for opinions is if it's an opinion that implies a statement of objective fact. So you've probably heard the terms libel and slander, and that's just the breakdowns for the type of defamation that you're talking about. So libel is written defamation. If you sue a newspaper or a magazine, that's going to be for libel because that's written publication. And so that would be where a newspaper has printed a statement about you that is untrue and it causes injury to your reputation. Written defamation, libel, the injury is presumed. You don't have to go out and show that, hey, I was injured by what the paper wrote that was untrue about me. Rather, your injury is presumed, and you just have to prove that the statement published was untrue. Slander, on the other hand, is oral defamation, and so this is what's spoken. And so, in those instances, except for the small exception of slander per se, which only a few things meet, in most slander cases, the plaintiff has to show that he or she suffered actual harm. So they've got to be able to tie the untrue spoken statements to actual harm. So you've got to show that because of what you said, I lost a job, or you lost a customer. So an example would be if you worked for a prior employer and you list that employer on your application at your next job, and that employer, your former employer, says things that are untruthful about you and you don't get hired, that would be an example of which you may have a claim for slander. So let's say that the employer, your former employer, tells the prospective employer that you got fired for your job because you had embezzled money. If that's not true and the prospective employer doesn't hire you because of that statement, you may have a claim against the former employer for slander. Now, slander per se that we talked about briefly is where the statement is so bad that on its face it qualifies as slander. And that would mean you do not have to show actual harm. You don't have to actually show that you lost a job or a customer. So a couple of the examples, the book lists a few of slander per se, is a statement that a person committed a serious crime. So a statement that you, just the example we gave of you embezzled money, that may be enough to qualify as slander per se. Now, in the example we gave, I wasn't thinking about it being slander per se or analyzing as that. I was saying it as an example to show the actual harm that you suffer. So the statement could be something less than they embezzled money. It could just be that you were an employee that had problems showing up on time, you were rude to your coworkers, and you were insubordinate to management. And if those things aren't true, then that's not slander per se, but it would be something in which you could potentially have a slander claim against the former employer if you lost your job, your potential job with a prospective employer. So we talked momentarily about um, this before, but for non-public people, so private people like you and I, for us to recover, all we have to show is that the defendant acted with knowledge that we've got to show one of three things: either that the defendant acted with knowledge that the statement was false, or they acted in reckless disregard for facts, meaning that they didn't care to find out if the facts were true or not, or we got to show that the defendant was negligent in obtaining the true facts. They didn't try to find out. They didn't exercise proper care to find out and confirm whether the facts that they published were true or not. So we've got one of three ways that we can establish that they acted improperly. But if you do the negligence theory, the one in which they failed to take appropriate steps to find out whether the facts were true or not, then you've got to show actual damages. So that goes back to like what we were just talking about this a moment ago with slander. You're going to have to show that there is a loss of business or a loss of profit or a loss of a customer because of the untrue statements that were published. But now defamation for public figures, celebrities, public officials, like the president or, a famous actor like Brad Pitt, Angelina Jolie, Robert De Niro, the president, the vice president, governor, anybody like that is going to be a public figure, and they've got a higher burden because they have to show that the defendant acted with actual malice. So they can't show that they were negligent in obtaining the true facts. Rather, they've got to show that they acted with knowledge that the statement was false or with a reckless disregard as to whether it was false. So they either knew it was false or they disregarded it in seeking to find out whether it was false. So that burden of showing actual malice almost makes it to where it is impossible to prove these defamation claims against public figures. So you may have, you see things where the president or someone else may claim that they're going to sue for defamation. Well, as a public figure, they can make that claim and they can say those words, but them being able to say they're going to do that and them actually successfully recovering are two different things, and they're very difficult for a public figure to prevail on a defamation claim. As you would expect, a complete defense to a defamation claim is truth. If you can show that the fact that you claim was defamatory is true, then how can there be any damages? How can you have done anything wrong if what you published was only truthful? And so a complete defense to any defamation claim is proving that the alleged false statements are in fact truthful statements. Now the defendant is the one who always carries the burden to establish that the alleged false statements are in fact true statements. And if you establish the truthfulness of the statements, then you're going to have a complete defense to a defamation claim. The book also talks about absolute and qualified privilege. Those are possibilities, but they're very rare when they come up. But the book does talk about them, and they're good to know. The absolute privilege is going to apply to certain statements that are made by government officials, statements made in judicial proceedings, or statements made between spouses. The qualified privilege is mainly intended to protect statements that's made about one's own personal interests or business interests.